Welcome back to Winning Isn't Easy. I'm excited about this segment of our podcast. Listener submitted questions. Now, question number one. Hello, I live in Wisconsin and I have a very rare neurodegenerative genetic disease. And I was also misdiagnosed with MS for 16 years. After a long career in pharmaceutical sales, my employer told me on several occasions that I wasn't allowed to drive my company vehicle because I was a liability. Ultimately, they urged me to file for long-term disability, and I was approved. And then 2 years later, I was dropped. So I hired a lawyer. We appealed. I won. I was approved for Social Security disability benefits the same year. Now, 10 years go by, and all of a sudden, the disability carrier plan says, hey, you're no longer disabled. And this disease has progressed. So my question is there any recourse for me to pursue the litigation for an insurance code of violation, breach of contract, bad faith? And how can the average consumer hold an insurance company accountable for their total corruption? So that's a lot of questions, Sarah, and I'm going to try to take these apart. Now, because this is an ERISA disability policy or plan, the remedies, what you can sue for, is governed by the ERISA statute. And you cannot sue, unfortunately, for bad faith violations, for breach of contract. You just can't do that. There's no remedy in the ERISA statute. What ERISA will address is, or the things you can sue for are basically the payment of your back benefits and potentially the payment of attorney's fees. And so the remedies are limited under the ERISA statute. Now, if you had bought your own disability policy through an agent, it would be governed by state law. In this case, it would be governed by Wisconsin law. You could sue for a breach of contract. You could sue for bad faith, punitive damages, compensatory damages. You could ask for a declaratory judgment about what your benefits are. And so the remedies are even greater. And you have the right to have a jury trial. You don't have the right to a jury trial in an ERISA disability case. And insurance companies and plans understand that. They understand that the burden of proof is so high in an ERISA disability claim that your remedies are limited, that judges don't like ERISA cases, and that there's no jury trial. So they work that to their advantage. On the other hand, in a state law claim, carriers are quick to do the right thing. And if they deny or terminate benefits, they are even quicker to resolve the issue. Obviously, it really depends on what law governs your case. Now, one of the things that I think is really important is that in ERISA, one of the reasons there is an unlevel playing field is this clause called the discretionary clause. The discretionary clause gives the carrier or the plan the right to decide your benefits and interpret the policy provisions. And it basically says to a judge, your ability to overturn our decision can only be based on what's called arbitrary and capricious behavior or evidence. And I wish arbitrary and capricious really meant what those two words really mean. But judges are really loath to overturn a decision. Let me give you an example. In the 11th Circuit, the standard of review, I'm going to sort of reduce arbitrary and capricious to three things. One, the judge has to decide whether the decision was wrong. If they agree with the decision, you lose. If the judge says, number two, I don't like this decision, the judge is going to look at the evidence to see if there was enough quote unquote evidence that they made up that will explain, but not necessarily justify, their decision to terminate benefits or deny a claim. So if the judge says, I don't like this decision, there's not enough stuff the carrier created, then we go on to step three. And at step three, the issue is, was that decision influenced by bias? They have, the carrier of the plan has a dual role. They decide and they pay. It is very difficult, quite frankly, in the 11th Circuit to get discovery on this, but you have to prove all of those three things to convince a judge, at least in the 11th Circuit, that the decision is wrong. Why did I go on that rant? Well, one of the things that I think consumers can do is to really lobby their Department of Insurance commissioner to outlaw and prohibit the use of discretionary clauses in not only disability insurance claims, but group health claims. I know that you'll be fighting the insurance lobby, but that's my best advice to you as to how a consumer can really fight insurance companies and disability policies or plans. I wish I could say that we could sue them in state court, but that's not going to happen. So that's my best advice to you. And thank you, Sarah, for that great question. All right, question 2. What do you recommend to fight the fact that the insurance carrier only asks about physical symptoms as documented by an FCE when you have a condition that is invisible? The form that they send my neurologist asks nothing about cognition, neuropathy, fatigue, and weakness. I've had repeated neuropsychological testing, but the carrier doesn't ask about the neurological symptoms in the annual review. All right, so I'm going to break that question up into parts. You're right that there are many conditions that are not necessarily observable or have physical symptoms that could impact a person's ability to do their own or any occupation. And when I have a case like that, I try to supplement the forms that disability carriers use, attending physician statement forms, with a applicable Social Security disability form, because I'm also a Social Security disability attorney. And I find that the Social Security forms we lawyers have created really do ask the right kinds of questions about cognition, neuropathy, fatigue, and weakness. So let's take a condition, for example, like fibromyalgia. Fibromyalgia is a disease where the disability carrier plan wants to see generally a number of tender points on physical examination that are consistent with the diagnostic criteria for fibromyalgia. But it's very hard to document the symptoms, the cognition, the fatigue, the weakness, the neuropathy, because the neuropathy may not actually be consistent with a dermatonal pattern that can be seen in an EMG and nerve conduction study test. And so what I try to do in those cases is to make sure that my client is giving a really good interval history of their symptoms with examples, word finding difficulties, for example, memory, having to use phone alerts or sticky notes, the fatigue, the need to take naps. And I try to have that documented in terms of symptoms and functionality by having that documented in the medical records. So my clients will fill out what we call symptoms and functionality worksheets to supplement the medical records to make sure that they are complete. We also, in that particular case, would have the doctor fill out a fibromyalgia residual functional capacity form that addresses all these things: the fatigue, the weakness, the cognition issues, perhaps the neuropathy. And so we want to make sure that we're giving the doctor the right information with which to render an opinion. I can't answer specifically why in this particular case, why they're not asking about neurological symptoms. But if they're accepting that whatever symptoms you're presenting with are the cause of your disability, I wouldn't necessarily be raising my hand saying, well, you didn't think about this one. If they've thought about enough to say that you're disabled, don't rock the boat. If they are, on the other hand, saying we don't think you're disabled, then obviously you need to address this timely in terms of an appeal. Part of that is to get the doctor's reports that were the basis of the denial. I call them liar for hires. The liar for hire peer review report can and must be attacked. They may have cherry-picked the medical records. They may not have had all the medical records. They may not be competent and qualified to even render an opinion about your particular medical condition. So we go about attacking that and taking it apart. We may have your doctor address that. We may have an IME. We want to address the basis of that opinion and why it is they felt that you no longer were disabled or didn't meet the disability test. And it may be that we also have your doctors or the IME provider comment on why you wouldn't necessarily see objective findings on examination, but that the symptoms are consistent. So what's an example of that? A migraine. There is no gold, there really isn't a gold standard test for a diagnosis of a migraine. It's based on history, pain diaries, and clearly a migraine is quote unquote invisible for diagnostic purposes, but is really visible when you've got one. So in those instances, I like photos, I like videos of a person having a migraine or even having, and better yet, the migraine log. So I hope I answered those questions. And I want to thank you for tuning in to this week's episode of Winning Isn't Easy. If you found this episode helpful, please take a moment to like our page, leave a review, and share it with your family and friends. Of course, subscribe. And also, please note that at the beginning of each episode description, you'll find a link where you can send us questions or comments. And I love answering questions. Got it? So join us, please, next week for another insightful episode of Winning Isn't Easy. Thanks for listening.